January 15th, 2025. Raleigh, North Carolina. A clerk timestamps a clemency petition at 9:47 in the morning. The file shows 32 applications submitted to the governor's office in the past decade. 3 were granted. Families gather in waiting rooms across 7 states, anchored to procedural timelines that stretch years, sometimes decades. The law promised finality. A sentence carried out, a case closed. Court dockets reveal something else. Appeals filed and refiled, protocol challenges, mitigation evidence discovered late, DNA motions pending review. Black women represent less than 2% of death row populations nationwide, yet their cases illuminate systemic questions about race, gender, mental health, and the machinery of capital punishment. This is not a story of monsters. It is a story of legal processes, documented facts, and the space between judgment and mercy. The first case begins with a conviction in 1995. October 1995. Lumberton, North Carolina. The courtroom in Robeson County Superior Court. The judge reads the sentence, death by lethal injection. Carlette Parker, 26 years old, stands with her public defender. The case file records the charge, first-degree murder. The victim, her former husband. The prosecution presented evidence of premeditation. The defense offered limited mitigation. Childhood abuse documented in social services records, untreated mental health conditions noted by a single evaluator. Capital murder. In North Carolina, first-degree murder with aggravating circumstances makes a defendant eligible for the death penalty. The jury must find at least one aggravating factor and determine it outweighs any mitigating evidence. The trial lasted 6 days. Jury deliberation, 4 hours. The sentencing phase, 90 minutes. The prosecutor told the jury Parker planned the killing. He presented witness testimony. He emphasized violence. The defense attorney, appointed by the court, had limited resources. His mitigation investigation consisted of 2 interviews, one with Parker's mother, one with a social worker who had known her as a child. No psychological expert testified. No comprehensive mental health evaluation was conducted. The social services records told a different story, one the jury never heard in full. Physical abuse beginning at age 7, sexual abuse by a family member, 3 suicide attempts before age 18, 2 psychiatric hospitalizations as a teenager. The records existed. The defense did not present them. Parker's appeal was filed automatically, as required in all North Carolina death penalty cases. The direct appeal raised claims of ineffective assistance of counsel, improper jury instructions, and procedural errors. The North Carolina Supreme Court affirmed the conviction and sentence in 1997. State post-conviction proceedings began in 1998 and remain pending as of 2025. Clemency, the executive power to reduce or eliminate a sentence, including commutation from death to life imprisonment, represents the final opportunity for relief outside the courts. Parker has not yet filed a formal clemency petition. The numbers tell their own story. North Carolina sentenced 12 women to death between 1976 and 2025. The state has executed 0 women in that period. The state has executed 43 men. Parker became the first black woman sentenced to death in North Carolina in 8 years. That was 29 years ago. No execution date has ever been set in her case. The state has not conducted an execution since 2006, when it put to death Samuel Flippin. Litigation over the state's lethal injection protocol has prevented the resumption of executions. The Department of Public Safety issues quarterly status reports. Parker appears on every report, housed at the North Carolina Correctional Institution for Women, classification, death row. Parker's case would remain in appellate review for 3 decades. The question of adequate defense representation would return again and again. November 1989. Burlington, North Carolina. Alamance County Courthouse. Blanche Taylor Moore receives a death sentence for first-degree murder by poisoning. The evidence, arsenic levels in the victim's tissue consistent with deliberate administration over months. The victim, Raymond Reed, Moore's boyfriend, who died after prolonged suffering in October 1986. The prosecution built its case methodically. Arsenic in the body, access and opportunity, life insurance policies, testimony from medical examiners. The state presented Moore as a calculating killer who poisoned multiple victims over years. Authorities exhumed the bodies of Moore's first husband and her mother-in-law. Both showed elevated arsenic levels. No charges were filed in those deaths, but the evidence was presented to show a pattern. Moore's defense attorneys presented character witnesses. They called Moore's pastor. They called neighbors who described her as kind and helpful. They called no mental health experts. They introduced no psychiatric records. They presented no evidence of Moore's documented medical history, depression diagnosed in her 20s, documented suicide attempts, prescription drug dependency spanning 2 decades, treatment records from 3 psychiatric facilities. Mitigation, evidence of a defendant's mental health, trauma, or life circumstances used to argue for reduced culpability. In capital cases, mitigation evidence is presented during the sentencing phase after a guilty verdict. The jury weighs aggravating factors against mitigating factors. If mitigation is not presented, it cannot be weighed. Moore's trial attorney spent 11 hours total on mitigation investigation. He reviewed no medical records. He interviewed no treating physicians. He consulted no psychiatric experts. The state's expert psychiatrist spent 45 minutes with Moore, concluded she was competent to stand trial, and did not conduct a comprehensive evaluation of her mental health history. The jury deliberated for 3 hours on guilt. They deliberated 2 hours on sentencing. The verdict: death. Moore appealed. Her appellate attorneys discovered the psychiatric records, hospital admission notes, therapy session summaries, prescription histories, and filed them as new evidence in state post-conviction proceedings. The state courts ruled the evidence should have been discovered earlier. The claim was procedurally defaulted. Habeas corpus, a federal petition challenging the legality of detention or sentence, often the final avenue for death row appeals. Moore's federal habeas petition was filed in 2009. It remains pending in the Fourth Circuit Court of Appeals as of 2025. The North Carolina Supreme Court affirmed Moore's conviction and sentence in 1991. That was 34 years ago. Moore is now 89 years old. She has been on death row longer than any other woman in North Carolina history. She's been on death row longer than any current male inmate in the state. No execution date has ever been set. The Department of Corrections housing log lists her status: death row, medical housing unit, requiring assistance with daily living activities. By 2025, Moore had been on death row for 35 years, longer than any other woman in North Carolina history. No execution date had ever been set. June 2000, Houston, Texas, Harris County Criminal Courthouse. Erica Shepard, 19 years old, sentenced to death for capital murder. The charge: killing a woman during a robbery. The victim, Marilyn Sage Measher, 43 years old, beaten to death in her apartment. The prosecution's case: strong physical evidence, witness testimony, Shepard's own statements to police. The defense: a court-appointed attorney who conducted no independent investigation into Shepard's background, did not interview available witnesses, and presented no mitigation evidence during the penalty phase. Ineffective assistance of counsel, a constitutional violation when defense representation falls below professional standards, established in Strickland v. Washington in 1984. To prove ineffective assistance, a defendant must show the attorney's performance was deficient and that the deficiency prejudiced the outcome. In capital cases, this most often arises when defense counsel fails to investigate and present mitigation evidence. Trial counsel's mitigation investigation in Shepard's case: 0 interviews with family members, 0 requests for school or medical records, 0 consultation with mental health experts, 0 witnesses called during the penalty phase. The entire sentencing presentation lasted 30 minutes. The prosecutor presented victim impact testimony, photographs, and argued for death. The defense attorney gave a brief closing argument asking for mercy. He presented no evidence. Shepard's appellate attorneys, appointed after trial, conducted the investigation trial counsel should have done. They interviewed family members. They obtained school records. They obtained Child Protective Services records. They obtained medical records. The records documented physical abuse by Shepard's mother's boyfriends, beginning in childhood, sexual assault by a family member at age 11, running away from home at age 14, living on the streets, substance abuse beginning at age 15, documented cognitive deficits, an IQ test result of 78. The Texas Court of Criminal Appeals reviews all death penalty cases automatically. The court affirmed Shepard's conviction and sentence in 2003. State post-conviction proceedings followed. The trial court denied relief in 2008. Federal habeas proceedings began in 2009. Certificate of appealability. Federal court permission required to appeal a habeas denial, granted only when the case presents a substantial constitutional question. In 2018, the Fifth Circuit Court of Appeals denied Shepard a certificate of appealability on her ineffective assistance claim. The court acknowledged trial counsel's investigation was minimal, but found Shepard had not demonstrated prejudice, that a different investigation would have changed the jury's verdict. Texas executed 6 women between 1982 and 2024. The most recent, Kimberly McCarthy in 2013, Lisa Coleman in 2014. Both women were black. Both were convicted of murder. Both had their ineffective assistance claims denied on appeal. Shepard has been on death row for 24 years. No execution date is currently scheduled. Her clemency petition remains pending before the Texas Board of Pardons and Paroles. Shepard's appellate attorneys argued she should have been the 7th case to receive life instead, had the jury heard the full story. February 2002, Houston, Texas, Harris County Criminal Courthouse. Linda Carty, a British citizen and former Drug Enforcement Administration informant, receives a death sentence for capital murder in a kidnapping murder case. The victim, Joanna Rodriguez, 25 years old, mother of a 3-day-old infant. The prosecution's theory: Carty orchestrated the abduction and killing of Rodriguez to steal her infant child. Carty's defense: she was framed by co-defendants, all of whom received lesser sentences in exchange for testimony against her. The case rested heavily on the testimony of 3 co-defendants. All 3 made deals with prosecutors. All 3 testified Carty planned the crime. All 3 received sentences ranging from 20 to 30 years. Carty received death. Brady violation, the prosecution's. Failure to disclose evidence favorable to the defense, established in Brady v. Maryland in 1963. Brady material includes evidence that impeaches prosecution witnesses or supports the defendant's case. Prosecutors have a constitutional duty to disclose such evidence. Failure to do so violates due process. Carty's appellate attorneys claimed prosecutors failed to disclose deals made with witnesses, failed to disclose that witnesses had changed their stories multiple times, and failed to disclose evidence that co-defendants had greater involvement in the crime than they admitted. The federal district court reviewed these claims in 2016 and denied an evidentiary hearing. The court found any undisclosed evidence would not have changed the outcome. The trial itself lasted 1 week. The prosecution presented 19 witnesses. The defense presented 2. Trial counsel met with Carty 3 times before trial. He filed no pretrial motions to suppress evidence. He did not hire an investigator. He did not interview potential alibi witnesses whose names Carty provided. He presented no expert witnesses. Capital murder in Texas: murder committed during kidnapping, robbery, burglary, or other specified felonies. Automatically eligible for the death penalty. Texas juries in capital cases answer 2 questions. Is there a probability the defendant would commit future violent acts? Are there sufficient mitigating circumstances to warrant life imprisonment instead of death? Both questions must be answered to impose a death sentence. Carty's jury deliberated 8 hours on guilt. They deliberated 4 hours on sentencing. The verdict: death. International intervention has been significant in Carty's case. The British government has filed multiple diplomatic requests for clemency. Amnesty International has designated her a priority case. The European Union has submitted formal protests. The United Nations Special Rapporteur on Arbitrary Executions has called for a stay. All such interventions are considered by clemency boards but carry no legal weight in American courts. Carty filed a federal habeas petition in 2007. The petition raised claims of ineffective assistance of counsel, Brady violations, and discriminatory jury selection. The district court denied relief in 2016. The Fifth Circuit Court of Appeals affirmed in 2018. Carty petitioned the Supreme Court for review. The petition was denied in 2019. The Texas Board of Pardons and Paroles reviews clemency applications in capital cases. The board consists of 7 members appointed by the governor. In 2019, the board voted unanimously, 7-0, against recommending clemency for Carty. Under Texas law, the governor cannot grant clemency without a board recommendation. Carty has been on death row for 22 years. She is the only British woman on death row in the United States. No execution. Date is currently scheduled. The question persists. Did the jury convict the organizer or the scapegoat? June 26, 2019. Lawrenceville, Georgia, Gwinnett County Superior Court. Tiffany Moss sits silently as the judge imposes a death sentence for malice murder, felony murder, cruelty to children, and concealing a death. The victim, Imani Moss, Moss's 10-year-old stepdaughter, who died from starvation and abuse. The prosecution presented evidence of prolonged torture, burns, blunt force trauma, withholding of food and water over months. The defense presented nothing. Nothing, because Tiffany Moss waived her right to counsel and represented herself at trial. Ferretta writes, the constitutional right to self-representation established in Ferretta v. California in 1975. A defendant may waive the right to counsel if the waiver is knowing, voluntary, and intelligent. The trial court must conduct a hearing to ensure the defendant understands the risks of self-representation and is competent to proceed without a lawyer. The Gwinnett County Superior Court held a Ferretta hearing before Moss's trial. The judge advised Moss she would be held to the same standards as a trained attorney. The judge warned her she would be at a significant disadvantage. The judge asked if she understood. Moss said yes. The judge asked if she still wanted to represent herself. Moss said yes. The judge granted her request. Standby counsel was appointed to assist if requested. The trial lasted 3 days. Moss conducted no cross-examination of prosecution witnesses. She called no witnesses. She gave no opening statement. She gave no closing argument. She presented no evidence. She sat silently through the entire proceeding. The jury deliberated less than 2 hours on guilt. They deliberated 1 hour on sentencing. The verdict, death on all counts. Moss has a documented psychiatric history. Hospital records show diagnoses of major depressive disorder and post-traumatic stress disorder. Treatment records document childhood sexual abuse, domestic violence in multiple relationships, and 2 psychiatric hospitalizations for suicidal ideation. Moss disclosed none of this to the court during the Ferretta hearing. The question appellate courts now face: was Moss competent to waive her right to counsel? Can a defendant with serious mental illness make a knowing and voluntary waiver? And if the answer is no, what remedy exists after a death sentence has been imposed? Georgia law provides for post-conviction DNA testing, new evidence claims, and challenges to trial competency. Moss's appellate attorneys, appointed after sentencing, filed a motion for psychological evaluation in 2021. The court ordered the evaluation. 3 psychologists examined Moss. All 3 concluded she suffered from severe depression and PTSD at the time of trial. 2 of the 3 concluded she was not competent to represent herself. The Georgia Supreme Court heard oral arguments on the competency claim in 2023. The court has not yet issued a decision as of 2025. Imani Moss's family has remained vocal throughout the proceedings. Her grandmother, who had reported concerns to Child Protective Services multiple times before Imani's death, testified at sentencing. She read a victim impact statement that lasted 4 minutes. She described calling authorities. She described being told the case was investigated and closed. She described learning her granddaughter was dead 2 weeks later. Georgia has executed 1 woman since the death penalty was reinstated in 1976, Kelly Gissendaner in 2015. The state has executed 76 people total in that period. 75 were men. Moss is one of 2 women currently on Georgia's death row. The question haunts the record. Can a defendant with documented mental illness make a knowing, voluntary waiver of the right to defense? And if the answer is no, what remedy exists after a death sentence is final? September 1995, New Orleans, Louisiana. Orleans Parish Criminal District Court. Former New Orleans police officer Antoinette Frank receives a death sentence for first-degree murder of 3 people during a restaurant robbery. The victims: Officer Ronald Williams, 25 years old, Frank's former partner on the police force, and Ha Vu and Quang Vu, siblings working at their family's restaurant. The crime shocked the city. A uniformed officer turned killer. The evidence: overwhelming physical evidence, surveillance footage, surviving witness testimony. The prosecution emphasized Frank's status as a police officer as an aggravating factor. The district attorney told the jury this was a betrayal of public trust. He argued Frank used her badge and training to commit murder. He presented testimony from other officers who described their sense of betrayal. The jury agreed. Frank's defense was minimal. Court-appointed counsel presented no mitigation case. He called no witnesses during the penalty phase. He gave a brief closing argument asking the jury to spare Frank's life. He presented no evidence of Frank's background, mental health, or life circumstances. The trial lasted 2 weeks. The jury deliberated 6 hours on guilt. They deliberated 3 hours on sentencing. The verdict: death on all 3 counts of first-degree murder. Louisiana law at the time required 10 of 12 jurors to agree on a death sentence. The final jury composition: 10 white jurors, 2 black jurors. The vote: unanimous for death. Batson challenge an objection to race-based exclusion of jurors established in Batson v. Kentucky in 1986. The Supreme Court held prosecutors cannot use peremptory strikes to remove potential jurors solely because of their race. If a defendant makes a prima facie showing of discrimination, the prosecutor must provide race-neutral reasons for the strikes. During jury selection in Frank's case, prosecutors used peremptory strikes to remove 5 of 6 black potential jurors from the panel. The defense objected. The trial judge held a Batson hearing. The prosecutor provided reasons for each strike. One juror appeared inattentive, another expressed hesitation about the death penalty, another was too young. 2 others gave answers the prosecutor found concerning. Peremptory strike: an attorney's ability to exclude a potential juror without stating a reason, subject to constitutional limits. Each side in a criminal trial receives a certain number of peremptory strikes. These strikes can be used for any reason except race or gender. The trial court found the prosecutor's reasons were race-neutral. The court denied the Batson challenge. The Louisiana Supreme Court affirmed that finding on direct appeal in 1997. Federal courts reviewing the case on habeas corpus deferred to the trial court's factual finding. The Fifth Circuit Court of Appeals affirmed the denial of habeas relief in 2015. Frank has been on death row for 29 years. She is housed at the Louisiana Correctional Institute for Women in St. Gabriel. She has filed multiple appeals raising claims of ineffective assistance of counsel, prosecutorial misconduct, and racial discrimination. All have been denied. Louisiana has not conducted an execution since 2010. Legal challenges to the state's lethal injection protocol have prevented resumption of executions. The state has struggled to obtain the drugs necessary for lethal injection. Pharmaceutical companies have imposed restrictions on the sale of drugs for execution purposes. Louisiana officials have announced plans to modify the protocol but have not completed the necessary rulemaking process. Louisiana has executed 1 woman in its history, Tony Jo Henry, in 1942, by electrocution. The state has executed 28 people since the death penalty was reinstated in 1976. 27 were men. Frank's case tests whether the state will execute a second and whether evidence of jury selection bias will ever be enough to stop it. July 10, 2002, Columbus, Ohio. The governor's office releases a single-page executive order. Governor Bob Taft writes, "In light of substantial evidence of mental impairment and the unlikelihood of execution, I hereby commute the sentence of Deborah Denise Brown from death to life imprisonment without the possibility of parole." Deborah Denise Brown was convicted of murder in 1984 as an accomplice to serial killer Alton Coleman. Between May and July of 1984, Coleman and Brown traveled through 6 states, Illinois, Indiana, Ohio, Kentucky, Michigan, and Wisconsin, committing a series of kidnappings, sexual assaults, and murders. 8 people died. Coleman was the primary perpetrator. Brown was charged as an accomplice in several of the crimes. In Ohio, Brown was convicted of aggravated murder in the death of Tani Story, a 15-year-old girl killed in July 1984 in Cincinnati. The jury sentenced Brown to death. She was 21 years old at the time of sentencing. Brown's IQ was tested multiple times during legal proceedings. Test results ranged from 59 to 70. Psychologists diagnosed her with mild to moderate intellectual disability, dependent personality disorder, and possible brain damage from childhood head injuries. 5 separate mental health experts testified during state post-conviction proceedings. All 5 concluded Brown had substantial cognitive impairments. Commutation, the reduction of a sentence by executive authority. In capital cases, commutation typically changes a death sentence to life imprisonment without parole. Commutation does not eliminate the conviction, it changes only the punishment. Clemency boards or governors can grant commutation based on factors including doubts about guilt, mental health issues, or changed circumstances. Brown's appellate attorneys argued Coleman manipulated and controlled her. They presented evidence Brown met Coleman when she was 18, that she had the intellectual functioning of a child, that she was completely dependent on Coleman, that she followed his orders without question. They argued she lacked the mental capacity to form the intent necessary for capital murder. Life without parole, a sentence requiring imprisonment until natural death with no possibility of release. LWOP has become an alternative to the death penalty in many jurisdictions. Juries can choose between death and LWOP during capital sentencing. Some states require LWOP for certain crimes even when the death penalty is not sought. The Ohio Parole Board recommended against commutation in Brown's case. The board vote was 4-3 against clemency. Governor Taft disagreed with the board's recommendation. He issued the commutation order based on Brown's mental impairment and the disparity between her sentence and the sentences received by other accomplices in similar cases. Alton Coleman, Brown's co-defendant, was executed by the state of Ohio on April 26, 2002, 4 months before Brown's commutation. Coleman and Brown committed the same crimes together. Coleman was executed. Brown's sentence was commuted to life. The IQ difference between the two, approximately 40 points. Brown's commutation occurred during a period of heightened national attention to intellectual disability and death penalty eligibility. 2 years later, in 2004, the Supreme Court decided Atkins v. Virginia, holding that execution of intellectually disabled defendants violates the Eighth Amendment's prohibition on cruel and unusual punishment. Atkins established that defendants with intellectual disabilities cannot be executed regardless of their crimes. Ohio has commuted 11 death sentences since the death penalty was reinstated in 1976. 3 of those commutations were for women. All 3 commutations were based on mental health or intellectual disability claims. Brown is currently incarcerated at the Ohio Reformatory for Women in Marysville. She is 62 years old. She has been in custody for 40 years. She will remain in prison for the rest of her natural life. The clemency order is 3 paragraphs long. It contains the word mercy once. It contains the phrase mental impairment 4 times, 7 cases, 7 states. 7 black women sentenced to death between 1984 and 2019. The patterns emerge not from similarity of crimes, which range from poisoning to child abuse to armed robbery, but from similarity of systemic failures at trial and on appeal. Inadequate mitigation presentation, 6 of 7 cases. Parker, limited mental health evaluation. Moore, psychiatric history not presented at trial. Shepard, 0 mitigation investigation by trial counsel. Carty, failure to investigate co-defendant credibility and witness deals. Moss, self-representation with documented mental illness. Frank, no mitigation case presented. Only Brown received extensive mitigation presentation, which ultimately led to commutation. Time on death row tells its own story. Moore, 35 years, the longest. Frank, 29 years. Parker, 29 years. Shepard, 24 years. Carty, 22 years. Brown, 18 years until commutation. Moss, 5 years, the youngest case. Average time, 25 years. The national average for all executed inmates, 16 years. Not one of these women has been executed. Not one has an execution date currently scheduled. The numbers create a question the system has not answered. Women represent approximately 2% of death row populations nationwide. Since Furman v. Georgia reinstated the death penalty in 1976, approximately 370 women have been sentenced to death. 18 have been executed. That is an execution rate of less than 5%. For men sentenced to death in the same period, approximately 8,000 sentenced, approximately 1,500 executed. That is an execution rate of approximately 19%. Black women represent 13% of the female population in the United States. They represent approximately 40% of women on death row. In capital punishment, as in many areas of criminal justice, racial disparities are documented and persistent. 3 of the 7 cases, Parker, Moore, and Frank, involve no scheduled execution date after decades on death row. 2 cases, Shepard and Carty, involve international intervention efforts, foreign government petitions, and sustained advocacy campaigns. 1 case, Moss, involves the youngest victim and the most recent sentence, raising questions about mental competency and self-representation. 1 case, Brown, achieved commutation through extensive documentation of mental impairment. The legal issues recur across cases. Ineffective assistance of counsel, alleged in 6 cases. Inadequate mitigation investigation, documented in 6 cases. Mental health evidence discovered post-trial, 5 cases. Claims of racial discrimination in jury selection or sentencing, 4 cases. Protocol challenges preventing execution, affecting all cases in states that retain active death rows. Between 2000 and 2025, 3 states imposed formal moratoria on executions: California, Oregon, and Pennsylvania. 4 states abolished the death penalty entirely: Connecticut, Delaware, New Hampshire, and Virginia. 23 states retain capital punishment. Actual execution practice varies dramatically. Texas, Oklahoma, and Missouri conduct regular executions. Many other death penalty states have not executed anyone in over a decade. The policy question these cases illuminate: what purpose does a death sentence serve if it is never carried out? Is decades of uncertainty more humane than execution, or less humane than commutation to life without parole? Victim families wait for resolution. Defendants age in isolation. Appeals continue through state and federal courts. Execution protocols face litigation. Clemency petitions remain pending. And the fundamental status, death row, persists year after year without the finality the sentence was designed to provide. The cases ask whether gender affects the system's willingness to carry out capital sentences. The statistics suggest it does. Whether that disparity constitutes mercy or inequality, or an unintended consequence of appellate process, the system has not decided. 7 women, 6 still waiting, 1 commuted, no executions, no resolution. April 22, 2021, Washington, D.C. The Supreme Court issues a 6-3 opinion in Jones v. Mississippi, narrowing the scope of prior rulings on juvenile sentencing. The decision does not directly address death penalty cases, but defense attorneys across the country read it carefully. If mitigation standards are contracting for juvenile life sentences, what does that signal for death penalty mitigation claims on appeal? The legal landscape for capital punishment has shifted measurably in the past 5 years. Protocol litigation has affected every death penalty state. Multiple states face ongoing challenges to lethal injection procedures. Pharmaceutical companies have refused to sell drugs for execution purposes. States have attempted to obtain drugs from compounding pharmacies. Courts have ordered disclosure of drug sources. States have sought to protect supplier identities through secrecy statutes. The litigation creates delays. Execution dates are postponed. Appeals are extended. DNA testing has become a central issue in capital post-conviction proceedings. Technology has advanced. Testing methods unavailable at trial can now definitively include or exclude suspects. States have passed statutes allowing post-conviction DNA testing. Defense attorneys file motions seeking testing of biological evidence. Some motions are granted. Some produce exculpatory results. Linda Carty's case includes ongoing DNA testing motions. Results are pending. Racial justice legislation has emerged in multiple states. North Carolina passed the Racial Justice Act in 2009. Allowing defendants to present statistical evidence of racial discrimination in capital charging and sentencing. The act applied retroactively to all death row inmates. More than 150 inmates filed claims. The act was repealed in 2013. Some claims were reinstated after partial restoration of the law in 2020. Carlette Parker and Blanche Taylor Moore both filed claims under the act. Both claims remain in uncertain procedural status. Clemency trends show rare but high-profile grants. Oklahoma Governor Kevin Stitt commuted Julius Jones's death sentence in November 2021, hours before the scheduled execution. The commutation generated national attention. President Joe Biden commuted 37 of 40 federal death sentences in December 2024, converting them to life without parole. The federal commutations did not affect state cases, but created political momentum for clemency consideration. States that conducted executions between 2020 and 2025, 11. Women executed in that period, 0. Men executed approximately 150. The gender disparity persists. Pending death penalty appeals nationwide as of January 2025, approximately 2,300 cases. Average time from sentence to execution for those executed in the past 5 years, 21 years. The appellate process has lengthened as courts scrutinize constitutional claims more carefully and as protocol challenges add time to proceedings. For the 7 women in these cases, the developments create a paradox. Protocol challenges and litigation delays keep them alive, but the delays offer no resolution. Parker and Moore remain on North Carolina's death row with no execution date and no clear path to commutation. Shepard and Carty remain on Texas's death row despite international intervention. Frank remains on Louisiana's death row while the state cannot obtain execution drugs. Moss's competency appeal remains pending in Georgia. Brown received commutation, but only after 18 years of appellate advocacy. The legal landscape shifts slowly. A protocol challenge here, a DNA statute there, a clemency grant that makes headlines. For women on death row, these shifts create survival through delay, but not resolution. June 2019, Gwinnett County Courthouse, Lawrenceville, Georgia. Imani Moss's grandmother approaches the microphone at Tiffany Moss's sentencing hearing. Her voice is steady. She has waited 5 years for this moment, 5 years since her granddaughter's death, 5 years of court proceedings, 5 years of asking how the system failed to save a child. She reads her prepared statement. Imani called me. She told me she was hungry. I called the authorities. They investigated. They closed the case. Then she died. Victim impact statements, testimony or written statements from victims' families about the crime's effect on their lives, admissible during capital sentencing phases following Payne v. Tennessee in 1991. The Supreme Court held such evidence is relevant to the jury's sentencing decision. Families may describe the victim's life, the loss they suffered, and the continuing impact of the crime. They may not state what sentence they believe is appropriate. All 7 cases involve victims whose families sought justice through the legal system. The sentencing transcripts document their testimony. Their words appear in the record. Raymond Reed's family at Blanche Taylor Moore's sentencing. We watched him suffer for weeks. We did not know he was being poisoned. We thought it was illness. When we learned the truth, the betrayal was unbearable. 35 years of appeals. We have attended hearing after hearing. We do not have closure. Officer Ronald Williams's family at Antoinette Frank's sentencing. He served his community. He wore the uniform with pride. He was killed by someone who took an oath to protect. His murder was a betrayal of everything he believed in. We have waited 29 years for justice. Imani Moss's family at Tiffany Moss's sentencing. We tried to help her. We called authorities. We reported our concerns. The system did not listen. A child died because the system failed. Marilyn Sage Meosher's family at Erica Shepard's sentencing. She was a mother, a friend, a neighbor. She was killed in her own home. The violence was senseless. We want this sentence carried out. The victim families are not monolithic. Some advocate strongly for execution. Others express ambivalence. Some have supported clemency for the defendants. The diversity of views reflects the complexity of grief and the different ways families process loss. National surveys of crime victims' families show consistent division on capital punishment. Approximately 50% support the death penalty for the person who killed their loved one. Approximately 30% prefer life without parole. Approximately 20% support restorative justice, approaches that emphasize accountability without execution. Some victims' families have filed statements supporting clemency for the women in these cases. They cite the long delays, the defendant's mental health issues, or moral opposition to the death penalty. Other families have actively opposed any commutation efforts. Community responses to the cases have been similarly divided. Religious organizations have filed amicus briefs on both sides. Some denominations oppose capital punishment categorically. Others support it for the most serious crimes. Racial justice organizations have focused on the disparities in sentencing. Some community groups emphasize the suffering of victims and argue delays deny justice. The cases exist at the intersection of competing values: justice for victims, fairness for defendants, adherence to constitutional standards, recognition of mental health issues, acknowledgement of racial disparities, and respect for human dignity. The question the cases pose to communities: what do victims' families deserve from the justice system? Is execution necessary for closure? Or does the prolonged appellate process cause additional suffering? Would commutation to life without parole better serve the goals of justice? The families wait, some for execution, some for commutation, all for resolution, year after year, appeal after appeal, without end. The word appears in every death penalty statute: finality. The sentence, once imposed and affirmed on direct appeal, becomes final. The punishment follows, the case closes. That is the theory. The practice tells a different story, one written in decades of appeals, protocol reviews, clemency petitions, and DNA motions. For the 7 women in these cases, final has meant something else entirely: a legal status that can last longer than some natural life sentences. Time between sentence and execution has increased steadily since the death penalty was reinstated. In 1984, the average was 8 years. In 2000, the average was 12 years. In 2020, the average was 18 years. The trend reflects more extensive appellate review, more developed constitutional standards, and more litigation over execution methods. Multiple factors contribute to the delay. Automatic direct appeal in death penalty cases typically takes 3 to 5 years. State post-conviction review adds 5 to 7 years on average. Federal habeas corpus proceedings add 7 to 10 additional years. Execution protocol litigation adds variable time depending on the state. Clemency processes add more time. The procedural layers accumulate. Women on death row experience even longer delays than men. The average time from sentence to execution for women, 25 years. For men, 16 years, a 9-year difference. Possible explanations for the disparity: women may present more compelling mitigation evidence related to trauma and abuse. Juries may be more reluctant to sentence women to death. Appellate courts may scrutinize women's cases more carefully. Governors may be more willing to grant clemency to women, or states may simply be less willing to execute women regardless of legal merit. The execution rate tells the story most clearly. Of approximately 370 death sentences imposed on women since Furman v. Georgia in 1972, only 18 have resulted in execution. That is a rate of less than 5%. For men sentenced to death in the same period, the execution rate is approximately 19%. The disparity persists across all racial categories. Application to the 7 cases: Parker has been on death row 29 years with no execution date. Moore has been on death row 35 years with no execution date. Shepard has been on death row 24 years with no execution date. Carty has been on death row 22 years with no execution date. Frank has been on death row 29 years with no execution date. Moss has been on death row 5 years with appeals just beginning. Brown spent 18 years on death row before commutation. Combined time on death row for the 6 women still under sentence, 163 years. Combined executions, 0. The system has created a de facto outcome: life sentences that bear the name death row. Defendants live in isolation housing units. They have limited contact with other inmates. They cannot participate in general population programs. They experience the psychological effects of anticipating execution. But the execution does not come. Year follows year. Appeals continue. The status persists. The question lingers: is this prolonged uncertainty more just than execution, or less just than commutation to life without parole? Is it mercy to keep someone alive through appellate delay? Or is it cruelty to maintain the threat of execution indefinitely? The legal system is not answered. The cases remain open. The sentences remain in place. The women remain on death row. And finality remains theoretical. January 2025. 23 states retain the death penalty. 27 states have abolished it or maintained formal moratoria. The shift has been gradual but measurable. 6 states abolished capital punishment between 2007 and 2025. New Jersey, New Mexico, Illinois, Connecticut, Maryland, Delaware. 3 states, California, Oregon, Pennsylvania, imposed gubernatorial moratoria preventing executions while the statutes remain in place. The question for women on death row: does reform reach them or only future cases? State-level reforms have expanded in the past decade. Racial justice acts in North Carolina and Kentucky allow defendants to present statistical evidence of discrimination in charging and sentencing. The laws apply retroactively. Hundreds of inmates have filed claims. Parker and Moore both filed claims under North Carolina's Racial Justice Act. The act was repealed, then partially restored. Their claims remain in uncertain procedural status. Intellectual disability protections expanded following Atkins v. Virginia in 2002, which prohibited execution of intellectually disabled defendants, and Hall v. Florida in 2014, which barred states from using rigid IQ cutoffs. The protections came too late for Deborah Denise Brown, whose commutation was based on similar evidence before Atkins made such evidence constitutionally mandatory. Mental illness exclusions represent a growing reform movement. Several states have proposed legislation prohibiting execution of defendants with severe mental illness. No state has enacted such a statute yet. The American Bar Association and American Psychiatric Association both support the exclusion. Moss's case, with documented mental illness and self-representation, could test whether such protections will develop through litigation even without statutes. Prosecutorial discretion has shifted in some jurisdictions. District attorneys in Philadelphia and Los Angeles have announced policies against seeking the death penalty in new cases. The policies do not affect existing death sentences. Future capital sentences in those jurisdictions will decline to near zero, but the women already sentenced remain unaffected. Clemency remains the most direct path to relief for current death row inmates, but clemency is rare. National clemency grant rates for death sentences remain below 2% of applications. High-profile grants generate attention but do not change the overall pattern. Reform creates hope, but it does not create legal relief. The cases remain in limbo, neither commuted nor executed, held in a space the system did not design and does not know how to resolve. January 15, 2025. North Carolina Department of Public Safety. The quarterly death row population report, current population 136 inmates, 2 women, Carlette Parker and Blanche Taylor Moore. The record holds what memory cannot. Case numbers, docket entries, sentencing transcripts, appeal opinions, clemency petitions, victim impact statements, housing logs, medical records, protocol litigation filings. The documents accumulate year by year, creating an archive of decision and delay, of severity and mitigation, of crimes committed and punishments imposed but not carried out. 7 women, 7 cases, 7 distinct legal journeys through America's capital punishment system. 1 outcome resolved: Deborah Denise Brown. Death sentence commuted to life without parole in 2002 after 18 years of appeals. 6 outcomes unresolved: Parker, Moore, Shepard, Carty, Frank Moss, all still under sentence of death. No execution dates scheduled, appeals ongoing. Combined time on death row for the 6, 163 years. Victims whose families sought justice. 14 documented individuals whose deaths are recorded in court files, whose lives are memorialized in impact statements, whose families attend hearings and wait for resolution. Appeals still pending. 6 cases in various stages of state post-conviction review, federal habeas corpus proceedings, or clemency consideration. The systemic questions the cases illuminate. Does the death penalty function as designed when sentences are rarely carried out? What role should mitigation evidence play? And what happens when it is discovered late? How do race and gender affect sentencing, appeals, and clemency decisions? What do victims' families deserve from the justice system, execution or resolution? Between 1976 and 2025, the United States executed 18 women and approximately 1,500 men. The disparity raises questions no statute answers: whether gender affects the system's willingness to carry out capital sentences, whether that disparity constitutes mercy or inequality, whether prolonged uncertainty serves justice better than execution or commutation. The dockets remain open, The cases remain active, the women remain on death row, and the legal system that sentenced them to death continues to keep them alive, year after year, filing after filing, without resolution and without end.